There's another very, very important case initiated in the Supreme Court in the public interest. That is against the Supreme Court of Sri Lanka. There are a number of Chief Justices involved in this matter. The names of the judges are K Sri Pawan, former Chief Justice, Shirani Bandaranayake, former Chief Justice, Mohan Peiris, former Chief Justice, Sarath N Silwa, former Chief Justice, and Vijith Malalgoda, one of the judges in the Supreme Court. Judicial corruption in this country, nobody is there to take up these issues. Unless you establish an independent judiciary in any given country, any democracy, system is bound to fail. This matter was initiated for a very, very valid reason. Charges are very serious. The matter was initiated in the Supreme Court on 25th of March 2016. Unfortunately, the judges in the Supreme Court failed to take it up 4 consecutive years. 2016, 17, 18, 19, 20. Nobody was willing to take it up because the charges are very credible and they found it very difficult to deal with this matter. I will tell you one by one why these judges were charged for corruption. Let's start with K Sri Pawan. He was the Chief Justice when the national list issue was taken up in the Supreme Court. National list, I have already informed you, there is no provision in the Constitution to appoint defeated candidates to the Parliament. I made it clear to the citizens in this country what is there in the Constitution, Article 99A. That has not been approved by the Parliament, but the Speaker of that time, E L Senanayake, has certified something else. So therefore, it does not become part of the law. I asked the Chief Justice K Sri Pawan to appoint a special bench under Article 132(3), Roman 3. That is, you are right to ask for a special bench. The abuse of national list is a matter of national importance. But he held it is not a matter of national importance. So therefore, I made a special application to him by way of a motion to step down from the bench, but to appoint a special bench, right? And he went on to consider, he went on to make a special remark that my action taken against him amount to interference with the administration of justice. What happened in this country? The judiciary, since it is not absolutely independent, he is always inclined to defend the executive and the legislature. So he was finally appointed as a chairman of the commercial bank. I mean, more than 50% of the bank, the shares belongs to the government. He was duly rewarded with the chairmanship of the commercial bank. So that is the reason is abuse of public office of the judge of the Supreme Court, Chief Justice, to confer a benefit, that is to confer a favor or benefit to the people those who are appointed to the national list, through the national list to the Parliament by unlawful means. So that is the case against him. The second charge was against the Shirani Bandaranayake. You know, Shirani Bandaranayake was taken away. She was removed from the office by President Mahinda Rajapaksa for the simple reason she refused. I think it is the Devi Naguma bill, and there was another reason. She refused to give in to the pressure, and finally she was removed from the office unlawfully. The entire nation knows that a removal was unlawful. However, when the government was changed, when the Yahapalnas came into being in 2015, they promised her, okay, we will get you the appointment. We will reappoint you, but you can claim all your privileges, perks and privileges, pension, everything, but you can't hold the office. The dirtiest thing she did, she agreed with that. She claimed everything and she made an announcement, right? Before she was reappointed, and there was a news media, world media published, I think it was the Colombo Telegraph. When she was appointed, she said, on my own accord, I retire. But she managed to get all her perks and benefits and everything. But people had a great faith in her, but she let down the whole country for her personal benefit, which is that amounts to violation of Section 70 of the Bribery and Corruption Law. If you confer a favor of benefit to yourself, tantamount to a violation of Article Section 70, Act of Corruption. That is why she was charged before the Supreme Court for corruption. She was first charged before the Corruption Commission, but the Corruption Commission failed to conduct a credible investigation. Therefore, along with the corrupt members in the Corruption Commission, she was charged for corruption in the Supreme Court. Third person, Mohan Peiris. The whole world know, the Sri Lankan community know that when he was the Attorney General in this country, in number of cases, that he abused the public office of the Attorney General to confer favors to very many people occupying office in the legislature, executive, and the public bodies and the government, and even the private institution. In one such case, the allegation was robbing 619 millions of public funds by that company. There was a matter before the Supreme Court. Mohan Peiris, when he was the Attorney General, he completely disregarded the directions given by the Director General of Customs that time. He made a false submission to court and withdrew that case. Later on, he was charged along with the Colombo Dockyard Limited in the Supreme Court. When the Corruption Commission failed to discharge its office to charge him, he was charged before the Supreme Court. Who that time he became the Chief Justice of this country, Mohan Peiris. However, when this matter was pending before the Supreme Court, the Colombo Dockyard Limited, they paid everything, whatever the amount defrauded, with including 10 million additional forfeiture, that is a penalty. Amount of duty defrauded by the company along with the 10 million additional forfeiture was paid by the company. So therefore, his conduct was not fit to be a Chief Justice in this country. Therefore, he was charged for corruption before the Corruption Commission. But the Corruption Commission, when they failed, along with the Corruption Commission, he was charged before the Supreme Court for corruption. Fourth name is the Sarath N Silwa. Sarath N Silwa's conduct is well known to the people in this country. Sarath N Silwa is the person who made blunders in the Supreme Court. He is the one asked people for an apology for let Mahinda Rajapaksa off the hook. He was charged, you know, that there was a serious allegations against him in the Supreme Court for that is about abuse of tsunami funds. When that matter was before the Sarath N Silwa that time, he intervened and he in fact found fault with the police officers who inquired into the charges leveled against Mahinda Rajapaksa. And they were asked to pay penalties and forfeitures. But he allowed Mahinda Rajapaksa off the hooks, and finally he made a public apology. He said, Mata Samavan, Mata Samavan, Mata Samavan. It is I who helped him to, and get rid of this case. I who allowed him to off the hook.
Mahinda Rajapaksa tuma ada utani inni mama nisa. Mama මේ ළඟට ගියා නාරායන පිටේ මම හැමදාම යනවා අග්‍රවිශකාරයෙක් කාලෙත් මම යනවා ඔය පොදු දෙලෙන් වලට ගිහලා තමයි බඩු ගන්න. මට ආරක්ෂක කවදාවත් හිටියේ නැහැ. ගියාලා මම දන්නවා ජනතාව විපිරුනේ සමාජිකෙක්. මම කතා කරගෙන ඉන්නකොට පිටිට තට්ටු කරා පිටින් ගෑවිලා. මට ඒ වගේ දේවල් තිල් කරන්න ඉඩ දෙනවා මම. කිව්වා මහත්තයෝ ඕක ගැන කතා කරන්න ඕනේ නැහැ. ඔබතුමාට තිබුණ අවස්ථාවක් එක වාක්‍යයකින් මේ මිනිස්සයා හිරේට දාන්න. ඇයි ඔබතුමා ඕක කෙරුවේ නැත්තේ? මට උත්තරයක් දෙන්න දැන්. මම කිව්වා සමා වෙන්න සහෝදරය කියලා මං ආවෙන්න. සමාවෙන්න සහෝදරය. ඔබ හැමදෙකින් මුළු රටෙම මං ඉල්ලනවා සමා වෙන්න මට. සමා වෙන්න මට. එදා වරදක්කෝ කරලා මම මේ මිනිස්සයා හිරේ දැම්ම නම් මේ රට විශාල අගාධයකින් බේර ගන්න තිබුණා. විශාල අගාධයකින් බේරන්න තිබුණා.
Okay, that is a very serious abuse of office to confer a favor to Mahinda Rajapaksa, and entire nation talked about it, and people asked very many times why nobody charged Sarath N Silwa for corruption. That is what exactly Nagananda did. So therefore, that is why Sarath N Silwa was charged for corruption. And the last name is Vijith Malalgoda. Now he's the judge in the Supreme Court. The judge, was responsible when he was the president of the Court of Appeal. That time, Mahinda Rajapaksa was contesting for the third term. The third term, I think it is in 2015, which was challenged because the constitutional amendment brought into the constitution was not, it was whatever the provision applicable to the executive president, I think it's Article 35, there was no retrospective effect in that law. So therefore, whatever the amendment made was applicable to prospective effect. Therefore, Rajapaksa was not permitted by law to contest for a third term. Therefore, his nomination was challenged in the Supreme Court. Before he tendered his nomination, it was challenged before the Court of Appeal. But this judge, who was the president of the Court of Appeal that time, right before the nominations was tendered to the Election Commission, the case record disappeared from the courthouse. And then the registrar of the court, he was put to the box and questioned. And how come that happened? When somebody initiates a case, there has to be a petition, affidavit, then motion, and whatever the documents referred to in the petition. When he was questioned as a witness in the court, he acknowledged that there is no reason. He said the court will never register a case unless these documents are there. However, this judge said, this matter, when it was initiated, the Court of Appeal, there was no petition, which is a false statement. So that is why this judge was charged for corruption. But during that time, I remember, he made a serious allegations against me, that is the counsel who initiated all this action in the public interest. He said, for that particular reason, I told him very many times in the Court of Appeal, when my matters, whatever the matters I presented in the court, not to appoint an independent bench because I had lost confidence in him. First case he did, second case also he did, third case he said, no, I am going to take it up before myself. So when I said, I had to make a statement in the open court, he asked whether I don't like his face. I didn't like his face. I said, that is not the issue. I told him in the open court that I have no confidence in him to present the case. For that statement, I made a statement that I have no confidence in the case because there was a motion filed in court requesting him to appoint a different bench. But he is the one who created the issue. To make it an issue in the open court, I had to make that statement, for which I was suspended from practice for 3 years. Like 3 years I was suspended from practice. This is the case about the judicial corruption case initiated in the Supreme Court. It was dispensed with on 16th of June 2020 without permitting the petitioner, that is me, to present the case before the Supreme Court. That is the state of affairs in the Republic of Sri Lanka. After 4 years, 20 June only, the decision was made by the Supreme Court that court cannot permit the petitioner to present the case, citing flimsy technical ground. They say that the notices have not been served on the respondents and therefore petitioner cannot present the case. That's a silly ground. That the real reason is that the Supreme Court did not want to expose these judges in public and to question their character and integrity in the open court. Therefore, the petitioner was not permitted to present this case before the court. Thank you.